In every case not involving slavery, quote, we find that the Constitution has recognized the general principle that allegiance and citizenship depend on the place of birth, end quote, use solely. But sadly, Justice Curtis was in the minority, and we had to fight a civil war to end slavery in this country.
But after the Civil War, Congress passed the Civil Rights Act of 1866, which said that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Mm-hmm. Now, that law was controversial. Welcome to Law and Chaos, where the DOJ is handing out cash to Trump's cronies. The Supreme Court is going to hear the administration's truly terrible arguments on birthright citizenship, and Sam Bankman-Fried's mom needs to take a Xanax. We got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I am great, Liz. How are you?
I mean, I'm getting ready for Passover. It's fine. I gotta go make some flourless chocolate cakes like the second we finish this record. Gotta get it done, you know, like
step by step. I could go for a flourless chocolate cake right about now.
Well, who couldn't? They are kind of the best. But like, you gotta do it one thing every day. Otherwise, it's like the day of, and then you're stressed out, and you have like you're like too stressed out. You're in a bad place. So I'm trying one thing at a time. Got to do some brisket. Got to do my cakes. Okay, we got a lot to talk about today. Obviously, the birthright citizenship case is being argued before the Supreme Court this week. The administration has some truly terrible arguments. Andrew, you are going to break down all of them for us. We're going to be elaborately angry about Michael Flynn and the settlement and what it looks like is about to happen. Spoiler alert.
Not angry enough, though.
Yeah, spoiler alert. That's going to be a raid on your taxpayer dollars. Fun. But before that, we have
dun-dun.
Docket alerts. Dun-dun-dun. Okay, in three-hat dance news, the House Judiciary Committee voted to do away with the requirement that U.S. attorneys be confirmed by the Senate.
Oh, they did. In related news, the mice voted to bell the cat.
Yeah, I'm pretty sure even Republicans in the Senate aren't going to vote for something that gives them less power. Right. And this isn't just like a minor procedural quirk. We've talked for a year now about Trump's refusal to do what every president has done for 100 plus years and nominate U.S. attorneys who can get the buy-in of blue state senators or red state senators if it's a Democratic president and move forward under the blue slip rule.
Yeah, let me unpack that a little bit because the blue slip rule actually isn't a codified rule of the Senate. It's just a tradition, and it has somehow survived the era of Trump where they've blown up every other norm that we thought was sacrosanct.
Not filibusters, not yet.
Don't say that out loud. Okay, here's how it works. When the president nominates a U.S. District Court judge or a U.S. attorney, the chairman of the Senate Judiciary Committee, right now that's Chuck Grassley from Iowa, the chairman sends a literal blue piece of paper to the two senators from that nominee state. If the home state senators approve, they send back a positive blue slip, and each one gets a vote, right? And if not, they can withhold their slip or send back a negative one. And without two positive blue slips, the nomination by agreement just doesn't get advanced out of committee for a full vote. And I should say, over time, blue slips have applied to different nominees, right? They used to apply to circuit judges as well, and then that became too politicized, so it got blown up. And the tradition has waxed and waned as to whether you need two positive blue slips or just one. But the baseline principle endures. And actually, I think that because it's just a tradition and not a rule that you can game at the edges, like that's actually served as restraint on blue slip holds.
Oh, interesting.
Right? Yeah, like obviously Democrats don't like anybody that Trump has nominated for the judiciary or to be prosecutors, but if you blue slip everyone, eventually your colleagues will stop asking you for your opinion. Yeah. So despite everything, the blue slip rules really worked for over a century to force presidents of either party to talk to senators before you nominate a judge or prosecutor who's going to serve in their state and find somebody who, and really the threshold is like, okay, who can I put forward who doesn't make you want to vomit?
Which Trump takes as a personal affront, which is why he's tried to jam in his cronies like Alina Habba and Lindsay Halligan and gotten slapped down in court. So now the goobers in the House are trying to change the law to conform to what Attorney General Bondi says it is when she's in court, when she's defending what she's already done. She says she's entitled to make infinite consecutive 120-day interim appointments, even of the same person.
So the Attorney General is saying she can just tap the same person every 4 months and leave them in a job that requires Senate confirmation indefinitely. Like, why would any president ever send anyone to the Senate ever again if that's the law?
Right. And the House Judiciary Committee also wants to cross out the provision of this statute, which allows judges in the district to fill a vacant U.S. attorney slot if there's no one Senate confirmed. No, to be clear, it's not the entire House Judiciary Committee, right? This thing passed on a 12-11 party line vote.
Yeah. That particular provision is 28 U.S.C. Section 546D. We've talked about it a lot on the show. And by sheer coincidence, Liz, in New Jersey, the Department of Justice finally tapped out last week and agreed that they were not going to fire the person that the district judges confirmed to be U.S. Attorney for New Jersey, pursuant to that section, 546D. The judges picked a longstanding veteran of the U.S. Attorney's Office, a guy named Robert Frazier, and Frazier is now offering to secure superseding indictments in cases that have Alina Habba's name on them, to belt and suspender it, right? So that there's no risk that those cases get dismissed after the, we could call it procedural weirdness. I would say defying the law, right?
Yeah.
So Frazier's office has offered to do it in the pending case challenging the leadership structure of the U.S. Attorney's Office and in, quote, similarly situated cases under Mr. Frazier's authority, which should moot the authority-based challenges to those charging instruments.
Yeah, I just keep thinking about Judge Qureshi yelling at that line attorney 2 weeks ago and saying, here is your risk. This is your risk, right? The risk of shoehorning in these cronies is that the entire case might fall apart because it was supervised by someone who never had the power to call herself U.S. attorney. And that defendant in that particular case was a horrendous child sex abuse material case. And the judge was furious that the Trump administration would risk letting that guy walk because it was in this pissing match with the judges and the Senate over U.S. attorneys. And
to layer on top of that was a case that the DOJ had already botched in spectacular fashion by not looking at the evidence. I'm really so curious whether the administration starts acting normal in other jurisdictions now and, huddling up with the judges to just get somebody competent on the job. Are they going to leave this thread hanging in the Eastern District of Virginia where they tried to get in Halligan and failed? Or what about the Northern District of New York? That's another three-hat dance jurisdiction. Like, I guess my question for you, Liz, is do you think that it is just the judges in New Jersey who forced the administration's hand, or what do you think?
I think it's probably going to be a case-by-case basis, right? In Los Angeles, they have a guy named Bill Asaley, who's in the Central District of California, and he's serving as first assistant. I think that they have the same arrangement in Nevada. So what they have is the guy kind of saying, well, I'm the number two in command and there's no number one. So, the number two job doesn't have to be Senate confirmed. And it's functionally the same thing as having a U.S. attorney without the apparent level of risk.
Yeah, I'm curious on level of risk because it is the same practical consequence as Pam Bondi's maximalist argument.
No,
right?
I don't agree with that at all.
I mean, if you can have your number two first assistant run things without a Senate confirm, why would you ever bother to nominate somebody to run the office?
I'm in 100% agreement with you, but not to get too deep in the weeds on our docket alerts. But in this particular jurisdiction, in New Jersey, they had this weird tripartite structure that was not the first assistant U.S. attorney. I mean, the first assistant U.S. attorney is an actual job. Whether that person is wielding the authority in a practical matter as U.S. attorney may be one thing. But also, in addition to that, the judges in other jurisdictions haven't been so aggressive as the judges.
That's a fair point.
So I think that they will take it on a case-by-case basis. And, depending on whether they can work something out with the judges in the district as they were able to hear. Okay, Speaking of loose ends and loose screws, the DOJ has, quote, settled a lawsuit brought by Robert Kennedy and his merry band of internet trolls way back in 2023. Also, a coalition of red states who were so mad about the government censoring the media.
Yeah, there is nothing Republicans hate more than a president threatening media outlets over what they allow to be published.
Do I detect a hint of sarcasm here?
I mean, you have FCC Chair Brendan Carr out there bragging in public about how he's defunded PBS and gotten rid of all these liberal voices from network TV. Yeah. So, you tell me.
I mean, fair. Okay, so back in 2023, Kennedy and a bunch of gross weirdos sued Joe Biden because the White House had the temerity to point out COVID and election misinformation on Twitter and Facebook and suggest that it might behoove those platforms to remove it in accordance with their own terms of service. That case was consolidated with a similar one filed by a coalition of red states in the Western District of Louisiana, where they wound up in front of Judge Terry Doughty, a 2018 Trump appointee and an absolute lunatic. He issued an injunction barring the government from talking to social media sites at all, and the Fifth Circuit trimmed it back a fair amount, but still, it was a ban on the government.
Yeah, and then that went to the Supreme Court, and in a 6-3 decision in June 2024, the Supreme Court vacated the district court's order because none of the parties had standing to seek injunctive relief, which, okay, when you put it that, I mean, it makes it sound like it was some kind of procedural ruling, but that, I think, understates what the Supreme Court was saying, right? Justice Barrett wrote for the court, and she really laced into Judge Doughty for misstating the facts. She called his statements, quote, clearly erroneous, which is the standard for review of fact-finding by district court judges, something you almost never see an appellate court say, and for failing to conduct the appropriate First Amendment analysis under the proper legal standard. But this is 2024, right? Like the pandemic was over. There was no immediate election to contest. And none of these plaintiffs were in any more danger of having their crazy posts censored. So that meant they weren't entitled to injunctive relief. So the court sent it back to Judge Doughty with instructions to basically start doing real law, you weirdo.
Right. But then Trump got elected and started censoring the shit out of broadcast media, although not as much social media since Musk took over Twitter and turned it into a Nazi bar. Kennedy is now, of course, part of the cabinet. He's making America healthy again. So he and the rest of the randos wandered off and failed to prosecute their part of the case. And then the states and the Justice Department started looking for an off-ramp because this troll suit really no longer served their purpose. And last week, the parties signed a stipulated settlement. They all pointed to this executive order Trump signed on January 20th, 2025. That's more than a year ago, in which he purported to restore freedom of speech and end government censorship. And they all said, yay, problem solved. No thing to see here anymore. So they all declared victory and went home. The New Civil Liberties Alliance, which is like Timu ACLU, but for like reactionary dickheads, put out a statement celebrating this milestone victory for the First Amendment free speech rights.
Look, I know outrage fatigue is real, but honestly, Trump supporters pretending to be pro-free speech and anti-censorship while their leader threatens late-night comedians and conditions media mergers on changing the content of broadcast news is a lot.
Yeah. Okay. Let's spend a hot second today talking about Sam Bankman-Fried and his mommy issues.
Dear.
We haven't talked about young Sam enough, Andrew. I mean, I guess we got busy talking about Trump burning the country down and all the lawsuits trying to stop him. And like, darn it, we too deserve nice things that don't involve Justin Baldoni and Blake Lively. Although there is a big ruling in that case coming this week. So watch this space.
You are right, though. I say Law and Chaos could have a little Bankman-Fried for a treat in the interim.
SBF teaches Civ Pro.
I mean, it's more like Professor Barbara Fried teaches Civ Pro, but as with Justin Baldoni, not on purpose.
Yeah. Okay, so in 2024, a jury convicted young Sam of fraud and money laundering in connection with the implosion of his cryptocurrency exchange, FTX. He would like a new trial based on blah, blah, blah. Who cares? It's not going to happen.
Newly discovered evidence pursuant to Rule 33 of the Federal Rules of Criminal Procedure. That's his theory anyway.
I mean, fine, whatever. It's, again, not going to happen. Okay, so in theory, Bankman-Fried is filing this motion pro se. He does he has lawyers, but I don't know. They're not on this motion. Maybe they're thinking they won't get paid, or they think it's too stupid for whatever reason.
No los dos.
I mean, he purports to be filing this on his own account. But his mom appears to be doing a fair bit of the work here.
Yeah. We should note that his mom is a legal ethicist and professor at Stanford Law School. Or she was. I think she might have been forced to resign when it emerged that she, played a role in advising her son. But so did her partner, Joseph Bankman, that's Sam's father, and he's still employed by Stanford.
I mean, I can't speculate on that apparent inequity. I mean, I can, but I won't. Anyway, on February 5th, Barbara Fried docketed the Rule 33 motion on her son's behalf, which is not entirely kosher since pro se litigants have to file as pro se litigants, right? They're not supposed to have someone else, even their mom, acting as their unofficial lawyer.
Yeah, I think that maybe understates it a bit. Like we talked last week about the judge in New Jersey not letting the assistant U.S. attorney speak in court when he hadn't entered an appearance. Entering an appearance is more than just a procedural hurdle, right?
Right.
It is essentially putting yourself professionally on the line, vouching for what you say to the court, making yourself responsible under Rule 11 for the content of what you file. It looks like what Barbara Fried wants to do is put stuff on the record without doing that, and that's not a thing you're allowed to do.
Yeah. Okay. So that's essentially what the court said. So back in February, when Barbara Fried docketed that Rule 33 motion, the court just kind of ordered the government to respond. The second time she wandered into the docket was March 12th, when she wrote a letter in her capacity, quote, as the holder of power of attorney for Sam Bankman-Fried, requesting an extension of time to respond to the government's reply brief because her son was being moved between facilities and didn't have access to a computer or his files, which is a rational thing to ask. Mm-hmm. And yet, so Judge Kaplan's response on March 16th was as follows. Ms. Fried is not a member of the bar of this court, has not sought leave to appear pro hoc vice, and has not filed an appearance. A power of attorney granted by the defendant does not authorize her to seek relief from the court or otherwise to participate in this litigation. The court, of course, understands that Ms. Fried is the defendant's mother, was trained and practiced as a lawyer, and has taught at Stanford Law School. Nevertheless, with no disrespect, she lacks standing to file papers or seek relief in this case. Indeed, Bankman-Fried is represented in this matter to this day by 3 members of the bar who have appeared here and who do have standing to act on his behalf. It is appropriate also to mention the fact that Ms. Fried's attached letter to the court bears no indication that it was served on the U.S. Attorney's Office, which should have been done if the letter had been appropriate in the first place. Moreover, court staff have advised that Ms. Fried, or someone so identifying herself, left a voicemail message on the chamber's telephone line. The court does not accept telephone calls from litigants or from members of their families. In the circumstances, the due date for any response to the government's opposition to Bankman-Fried's previously filed motion is extended on the court's own initiative from March 18th to and including March 23rd. This will afford time within which Bankman-Fried or his counsel may seek a further extension if that is desired and for the government to respond to Ms. Fried's letter.
I mean, we've talked about what do you do for your kids, but I think the moment that crosses over from zealous parental advocacy to, come on, you know better than this, is the ex parte communications, right? Like that just is not a thing you do as a lawyer. Even if you are represented, you do not privately talk to the judge in your case or in your client's case.
Yeah, right. Not sending it to the, I don't even understand what the point of that was. Right. Not sending it to the opposing counsel. That's not a thing. I don't understand. Like, this woman has been a lawyer for a very long time, for like 50 years. Like, I'm not.
Yeah.
Okay. On the same day as that minute order, March 16th, the court gets another letter, but this one is supposedly from Bankman-Fried, and in it he's requesting another extension, which is what he's wanted the whole time. It is not signed by Bankman-Fried, or at least not with what's known as a wet signature. You know, nobody hit it with a pen. It's got the /S and then his typed name.
And I should say, in 99 cases out of 100, that's fine. Almost everything that I sign electronically now, right? But it does mean, in cases where there's a question mark about who's doing your homework, that could have been written by anyone. And as it turns out, the government was a teeny tiny bit suspicious. So they wrote into the court, There is reason to doubt that the March 16th letter purportedly submitted by the defendant was in fact sent by him. The letter was sent to Chambers by Federal Express, but according to the Federal Bureau of Prisons, by Program Statement 5800, inmates are not permitted to send mail via FedEx or other private carriers. Moreover, we note that while the letter's envelope says that it was sent by S. Bankman-Fried at Terminal Island DOC, San Pedro, California, 90731, the BOP facility at Terminal Island is a Federal Correctional Institution, FCI, not a DOC, which is an acronym for a California Department of Corrections.
Yeah, I'm pretty sure Bankman-Fried knows the name of the facility he's been in.
Yes, that is the reading between the lines. Continuing. And while the return address information suggests it was sent from San Pedro, where the facility is located, the FedEx tracking information for the package shows that it was picked up and shipped from Palo Alto or Menlo Park in California, which happens to be where Sam Bankman-Fried's mother lives. And then they add, finally, the letter is signed with a /S and not the defendant's actual signature.
I mean, that's awkward. So on the plus side, Judge Kaplan once again extended the deadline on his own initiative. But on the minus side, he ordered Bankman-Fried to file an affidavit by April 15th explaining exactly who drafted his Rule 33 motion for a new trial.
I feel like this might have the potential to go very badly.
I mean, I am a mother. I would do a lot of crazy shit for my kids. I might even do something as desperately stupid as this. But I do think that Bankman-Fried's parents are distinctly not helping. Like, let's cut this shit. There's one way out of jail for their kid at this very particular moment in time, and it involves kissing the president's ass and probably donating money to something that he wants or giving one of his cronies money. I hate it, but there it is.
Yeah.
And to his, I guess, very minimal credit, Bankman-Fried himself seems to have figured that part out. I mean, his parents are trying. And look, it's one thing to shred your own credibility by suddenly giving up everything you've ever said and like, I support the president's wonderful policies. Please pardon my kid. Because you don't get disbarred from that. You just get professional opprobrium.
Yeah.
Don't be doing this. Don't be doing what you're doing there.
Yeah, absolutely.
Okay, it is Tuesday, and so this is the day we thank our wonderful new subscribers at patreon.com/lawandchaospod or lawandchaospod.com.
Yeah, big thank you to our new supporters over on Patreon. That is Gansey, Neo Grendel, Tim Mumford, and Jason Parakoniak.
And over on Substack, thank you to Different Drummer, Frank Rogozuski, and Momvacate.
How appropriate. And you know how to join their ranks if you want to get the show ad-free. And for everybody else, we are going to take a quick ad break, and we will see you on the other side with everyone's least favorite former National Security Advisor, Michael Flynn.
Ew. Say at the outset that I have been covering Mike Flynn for almost 10 years now, and I am pretty salty about it.
Fair.
This jackass was leading chants of lock her up at the RNC in 2016 at the very same moment he was taking cash from the Kremlin media outlet RT and acting as an unregistered foreign lobbyist for Turkey. I mean, this is a guy who offered to black bag helicopter a Turkish imam out of the Poconos for $15 million while demanding that Hillary Clinton go to email jail for her stupid homebrew server.
Yeah, I think we all remember Michael Flynn's tenure as National Security Advisor getting cut short after 24 days because he had illicit conversations with the Russian ambassador, Sergei Kislyak, and then lied about it to the FBI. Flynn pled guilty to an 18 U.S.C. 1001 false statements charge twice and admitted under oath that he had violated the Foreign Agents Registration Act. But then Kraken lawyer Sidney Powell came into town and convinced him to withdraw his guilty plea, and Attorney General Bill Barr asked the court to drop the case.
which seemed at the time like the high watermark for corruption, but it was not.
No, it was not. So anyway, Judge Emmett Sullivan appointed a retired judge to argue against dismissal since the government and the defendant were clearly colluding. I filed an amicus brief arguing that the court did indeed have the power and ought to independently review any Rule 23 motions to dismiss that were filed with it for collusion. And it looked like Judge Sullivan was about to do that, and then Trump gave in, stopped this sort of backhanded rigmarole, and just pardoned Flynn outright, which mooted the case.
And then in 2023, Flynn went on to file a lawsuit against the Justice Department for malicious prosecution and abusive process under the Federal Tort Claims Act. Now, look, this lawsuit is garbage. It did not allege any violations of the FTCA. It was time barred, but it did have one thing going for it, which was that it landed on the docket of Judge Mary Scriven. Scriven is a Biden appointee, but she moves very slowly and deliberately. And she granted like 12 extensions to, she also let Flynn amend his complaint. And when she finally dismissed it in December of 2024, it was without prejudice. And she said, go ahead and amend again, right? So take your third crack at the apple, which he did after a couple more extensions of time. And then he filed in June of 2025 this third complaint. But by then, Pam Bondi and Todd Blanche were running the DOJ, and they decided that actually they'd like to lose this case, which they'd already won and were definitely going to win again. So in September, they asked for more time for settlement talks, yet more extensions. And in March, they said they were going to settle with Flynn for $1.25 million.
Which was not even the first time that Pam Bondi had stolen our taxpayer money to pay off Trump's friends and cronies. She paid $5 million to the family of Ashley Babbitt, who was killed trying to break into the Speaker's lobby on January 6th. She's talking about paying Trump $230 million for the, quote, raid at Mar-a-Lago and the subsequent Russia investigation. And now it's clear that the checkbook is out. Ed Martin, that loon and your favorite writing target who could not get confirmed by this Senate as U.S. Attorney for D.C. He has called for reparations for the victims of January 6th, by which he means the insurrectionists that Trump pardoned. 5 Proud Boys, including their leader Enrique Tarrio, were already suing the government in Florida. They were demanding $100 million because they got convicted of seditious conspiracy because they seditiously conspired to overthrow the U.S. government. And now a bunch of rando insurrectionists have filed a lawsuit also in Florida demanding $18.4 million just for the 3 named plaintiffs.
Yeah. Okay. So top line, clearly this is disgusting and corrupt, and we should say at the outset that the Justice Department is currently fighting the Proud Boys claim. They filed a motion to dismiss in August. That has not been adjudicated as yet. Yeah,
the Middle District of Florida is no rocket docket.
No.
But I do want to talk for a second about the theory of this case, which is kind of a mess.
The Proud Boys case.
Yeah, right. No surprise that, the theory of their case is kind of a mess. It has 4 counts. 3 are Bivens actions, which is the judicially created vehicle to recover monetary damages against federal officers acting in their individual capacity under ostensible color of federal law for violating a person's constitutional rights. The Proud Boys are suing individual FBI agents for Fourth Amendment unreasonable search and seizure, Fifth Amendment violations of due process, and their Sixth Amendment right to counsel. Their theory, to the best that I can ascertain it, is that the FBI raided their homes without probable cause, spied on their attorney-client communications, planted a government informant, and destroyed or fabricated evidence. Bivens claims are almost impossible to win, and these guys were convicted by a jury. So this case is the definition of going nowhere. They have also added a common law claim for malicious prosecution, which is just offensive.
I mean, they're represented by an IP lawyer from Virginia, which may account for the unorthodox pleading.
That is 87 steps up from their original lawyer, who was named, I am not kidding, Augustus Saul Invictus, changed his name to that. He is connected to Alex Jones. He thinks that Alex Jones has a conspiracy to tank his own case. I could do an entire episode on this weirdo. Maybe we will someday.
Well, maybe not. Since he got disbarred after getting getting convicted of burning an object with intent to intimidate at the Unite the Right rally in Charlottesville. So he couldn't represent these guys anymore. Sad. Anyway, it's not entirely surprising that this case is a little non-standard. I mean, aside from every other thing, it's also far outside the statute of limitations.
Yeah, right. So as we talked about with Mike Flynn, you can sue the feds for malicious prosecution, right? But you have to do it in accordance with the Federal Tort Claims Act, right? And its specific and precise waiver of sovereign immunity. That act procedurally requires you to submit a Form 95 administrative demand first and then wait for the federal government to reject that before you can sue. These doofuses didn't even do that, but I actually do want to contrast this case with the new January 6th case that was filed this week, because that is a pure FATSA case, right? And it suggests to me, I mean, I don't want to go too much radio signals in the dental filling, but like that the DOJ kind of seems to be in cahoots with these guys to engineer a facially plausible lawsuit as a vehicle to pay them potentially hundreds of millions of tax dollars, right? Or at the very least, that the January 6th defendants have interpreted the Flynn and Babbitt settlements as the Trump DOJ hanging out a sign that says, hey, file your Federal Tort Claims Act claim and collect your check because we're open for business.
Right. I agree with everything that you said, but it really does put the statute of limitations issue in stark relief, because this lawsuit isn't about the subsequent prosecutions that these people were, the January 6th insurrectionists, most of them were prosecuted, or lots of them. This is about something that happened on that day, January 6, 2021. So you have 2 years from your injury by the government to submit your claim. Under the Federal Tort Claims Act, you then have to submit something called a Form 95 detailing your injury and the relief you're demanding, and the government has 6 months to respond, after which your claim is what's called deemed denied. Right. That's one of the reasons Flynn's claim was time-barred, because he submitted the Form 95 in February of 2022, and it was deemed denied in August of 2022. So that meant he had to file his lawsuit by February of 2023, which he did not. He waited until March, which is close, but no cigar. These plaintiffs aren't even close, right? Because by their own reckoning, if you have 2 years from January 6, 2021, their last day to submit their claim was January 6, 2023, in the best case scenario. And so like roughly July 6, 2023 is when they were deemed denied in that best case scenario. So they had until January 6th of 2024 to sue. That was the last date. That was the last date any of them could have filed a lawsuit based on what happened at the Capitol.
Well, it's only 26 months too late. Maybe they can get a waiver.
Or maybe the DOJ will decide it doesn't care. I mean, the way it did with Mike Flynn.
Yeah. I think that is clearly the bet here. I mean, the lawsuit has 3 groups of putative class members. Group 1 is 35 people who have submitted their Form 95s and have gotten no response, which, as you explained, Liz, is a deemed denial.
Incidentally, that group includes one of the Proud Boys from the other case, the Bivens case, Dominic Pezzola. He stole a riot shield from a cop and used it to break a window. He was the first one to breach the Capitol building. He's a peach. Actually, one of the named plaintiffs in this case, A.J. Fisher, is also a Proud Boy. He was charged with assault, but he was pardoned before his conviction was finalized.
I can't even. Okay. Group 2 is 11 people who submitted their Form 95s and have not heard back.
Which, by the way, is the normal way that this goes, right? The government almost never responds to those claims because they know you're going to sue them. They're not going to give you more evidence. They just let it be deemed denied. And if you don't like it, you can sue.
Right. Which makes Group 3 even more ridiculous, because the complaint says there are hundreds or even thousands of other people who haven't submitted their Form 95s, but they should be able to recover anyway because the government never answers and the court can't require you to do something that's futile. And no. If you want to get around sovereign immunity, you got to jump through the statutory hoops. I mean, it is hard. I do not mean to suggest that this is the worst problem with this lawsuit, okay? These claims are ridiculous on their face, but the argument of we don't have to file FATSA Form 95 claims at all to recover is maybe the stupidest.
Well, but as you said, if they're doing this because the DOJ has signaled that this is their preferred vehicle to open up the till and start handing out cash, I guess it makes sense.
Yeah, I guess. Can I make one more weedsy point on this before we go talk about birthright citizenship?
Woo! Yeah,
it has to do with the way in which this complaint was filed, which I think pretty much gives the game away. So the complaint says, The law enforcement officers were the Capitol Police and Metropolitan Police Department, that's the D.C. municipal cops, who were on the Capitol grounds at the request of the Capitol Police. At all times relevant, the MPD officers were under the direction and control of the Capitol Police. The MPD assisted as borrowed servants, and the United States is vicariously liable for the actions of the MPD. Now, here's why this is bizarre, right? Because in every previous real litigation case, you would much rather to have a state plaintiff, right? The MPD have them be acting as state officials rather than as federal officers, because then you can sue them under 42 U.S.C. Section 1983. That is the classic statutory remedy when state law officials acting under color of state law violate your constitutional or federal rights. Bivens, as we've talked about on the show, is supposed to be sort of an analog to fill in the interstices, but, to say, well, what happens if it's a federal agent who violates your constitutional rights? But since its inception, it's been effectively pared back to almost nothing. And the Roberts Court, I think, is getting ready. They've got a pending case. I think they're going to just abolish the Bivens remedy entirely.
Yeah.
The fact that these plaintiffs are trying to sweep state actors who would otherwise be subject to Section 1983 into a pile with the feds, calling them effective federal agents, and then trying to recover against them under the FTC, that's crazy. You would sue your lawyer for malpractice if he suggested you do that. So either their lawyer is an absolute goddamn idiot, or he thinks they're more likely to get a settlement under an FTCA claim than under Section 1983. And considering the way Michael Flynn made out, I think he might be right on that latter suggestion.
Yeah, I tend to agree with you. I also think that the government is in some sense softening us up by making so many of these insane little claims be paid out that we don't even hardly notice it when the $230 million that Trump wants for his, malicious prosecution in the Mar-a-Lago case goes out the door. I mean, I think that they're trying to kind of make it seem normal, which it definitely is not.
Yeah, I think that's right. That settlement may have already been entered. For all we know, we do not. So I think that's a good point. Okay, we're going to take another quick ad break. Unless you are a subscriber at patreon.com/lawandchaospod or over on our Substack at lawandchaospod.com, at which point, no ads for you. Not today, not ever.
And we're back. Okay. On Wednesday of this week, April 1st, the Supreme Court will hear oral argument in the case Trump v. Barbara. That is the Birthright Citizenship case.
Yeah. And this is a profound moment. I do not think that there are 5 votes at even this Supreme Court to invalidate birthright citizenship. So I think the result is going to be okay. But I think there are at least 2, right?
Yeah.
Clarence Thomas and Samuel Alito. And that would have been unthinkable 10 years ago. And I think part of what makes this such a dangerous moment is that the Trump administration is being aided and abetted by conservative legal scholars to sanewash an argument that any honest legal scholar, even on the far right, would tell you has zero merit. So let's talk about that.
Yeah, we'll be listening to this case for sure on Wednesday morning. And I think it's one of those ones that we'll know within the first 5 minutes of oral argument how it's going to land, right? Like in the tariffs case, Justices Kavanaugh and Barrett basically hammered Solicitor General John Sauer out of the gate. And by the same token, when we listened to the immunity case in Trump v. U.S., it was pretty alarming from the get-go because it seemed like such a crazy argument that they were making, and it was clear that the justices were entertaining it.
Yeah. The red flag I'm looking for in this oral argument is the word complete, because that is the qualification that this administration is trying to smuggle in to create an ambiguity in its interpretation of the 14th Amendment where there is none. And so I think in the first couple of minutes, if you hear Chief Justice Roberts or Justice Barrett use that word in a friendly question to Solicitor General John Sauer, then we are in trouble.
Yeah. Okay, let's unpack some of these assumptions. Let's start with what the 14th Amendment actually says. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That is the Citizenship Clause. On his first day in office, Trump issued Executive Order 14160, quote, protecting the meaning and value of American citizenship. It claimed to, quote, restore the original meaning of that citizenship clause as not granting citizenship to children whose parents are neither citizens nor legal permanent residents. Trump's order directed executive branch agencies not to issue citizenship documents such as Social Security cards or passports to children born in this country and to disregard state-issued documents such as birth certificates and driver's licenses that do recognize citizenship. That executive order has been largely enjoined from being enforced for over a year, although various agencies, such as Homeland Security and the Social Security Administration, have developed guidance for how they intend to implement this policy if the Supreme Court lets it go forward.
Yeah. So the argument being made by the Trump administration is that the phrase subject to the jurisdiction thereof in the 14th Amendment is a substantive qualifier to the principle that if you're born here, you're a citizen. It is not. And we're going to talk about all the ways that we know that it is not. But I suppose I should start with flagging that this is what this administration does over and over again. Right? It looks to create ambiguity where there is none, and then it fills those interstices with these bad faith interpretations, and then says, look, there's a controversy. And now we are here stuck debating a thing that is settled law. I mean, this is the same playbook that flat earthers and creationists and vaccine skeptics run.
Right. So to understand why this is settled law, we have to start with the most shameful and reviled Supreme Court case in our nation's history. It's Dred Scott v. Sanford. In 1857, the Supreme Court said that if your ancestors were imported to this country and sold as slaves, you didn't count as a citizen, even if you were born here and even if you were a free person in a northern state that prohibited slavery. The rationale was that slaves were somehow separate from the American body politic. Mm-hmm. They could be under the protection of the United States and they could be forced to obey the law, but they owed no, quote, allegiance to the country. And therefore, they couldn't be made citizens and neither could their children.
Yeah. As a matter of jurisprudence, what the Dred Scott Court was wading into was a 19th century debate about citizenship between jus soli, the right of soil, and jus sanguinis, which is the right of blood. And even though English common law and every prior American precedent was jus soli, the Supreme Court essentially co-opted the jus sanguinis rationale to exclude black people from citizenship. And it's not hard to see this as motivated by the outcome, right? That debate is abundantly clear from the dissent. Justice Curtis, writing in one of the two principal dissents, said that in every case not involving slavery, quote, we find that the Constitution has recognized the general principle that allegiance and citizenship depend on the place of birth, end quote, jus soli. But sadly, Justice Curtis was in the minority and we had to fight a civil war to end slavery in this country.
But after the Civil War, Congress passed the Civil Rights Act of 1866, which said that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Mm-hmm. Now, that law was controversial. President Andrew Johnson vetoed it, but Congress had enough votes to override that veto, and they did. But Reconstructionists were worried that a future Supreme Court might try to apply the jus sanguinis rationale of Dred Scott to declare that act of Congress unconstitutional. Mm-hmm. So they drafted the 14th Amendment to explicitly amend the Constitution to make it clear that Justice Curtis was right and Dred Scott was wrongly decided, and you become a citizen by being born here, the end.
Yeah. So one of the things that you will find front and center in the government's brief in Trump v. Barbara is a claim that most of the world no longer accepts jus soli, right? They say hardly any developed country retains a rule of citizenship that resembles the United States' current approach. Even the United Kingdom, which pioneered near automatic birthright citizenship, abandoned it in 1983.
I mean, why would we give a shit how we don't care how any other country does. This is one of the funny things because they're always like, you're making us do Sharia law and all that other shit. Like, that's interesting, but not relevant what any other country does.
I could assemble Antonin Scalia's greatest hits of making fun of international law. But yeah, but let's take the claim at face value because there's sort of a kernel of truth buried here. Like most nations, particularly in Western Europe, don't automatically grant unconditional citizenship to everyone who is born there. Instead, they have various hybrid models. In France, for example, you're a citizen if you're born there and one or both of your parents were also born there, or if you're born there and you've lived there for at least 5 years. And I got to say that seems to at least resemble what we have here in the United States. And by the way, many countries do still have use solely citizenship, right? That Canada, Mexico, Brazil, most of Latin America.
Mm-hmm.
But as you point out, Liz, this argument would make no sense even if it were true, right? Like, as I might point out, hardly any developed country permits capital punishment. Hardly any developed country imprisons large swaths of its citizens, right? Like, I don't think the administration actually seriously intends to go down this path. Like, the point is, in 1866, we chose use solely. We inherited it from the English common law dating back to the 13th century Saxony. The Supreme Court briefly cast doubt on it in literally the most infamously wrong decision it ever issued, and Congress promptly amended the Constitution to say, no, that was wrong, it's this way. Again, case closed.
But okay, let's steal about the Trump administration's argument. In our last episode, Andrew, one of the ways you said we knew the Trump administration's interpretation of the Immigration and Naturalization Act was wrong is because it would read out and basically zero out another part of the law, right? By construing the mandatory detention provision as covering basically all immigrants, that would render all of these other provisions about discretionary detention as mere surpluses. Why would you have them if it was all covered by this mandatory detention provision? And, you know, that's one of the standard axioms of American law. You don't just read out parts of it. You have to read it in such a way as that the other parts make sense and cohere and exist.
Yeah.
So the argument that the government is making here is that the 14th Amendment contains the words "and subject to the jurisdiction thereof." And if it wasn't there, if you read it as if it doesn't make any difference, then you're treating those words as mere surplusage, and that's not a thing we do here.
And that, independently, is a fine principle. I agree with it. The answer is that we're not doing that, right?
No.
It is that qualification, the meaning of the phrase, and subject to the jurisdiction thereof, was really, really important as a matter of 19th century law. But because that law changed, it's now a historical footnote. So it's effectively been read out, but not read out from an interpretive standpoint. And that law is Indian law. And I should add, I use that term because indigenous legal scholars, including several who filed an amicus brief in this case, use it. But if you are a listener who is an indigenous person, you have thoughts about the appropriate, but please drop me a note. Anyway, I want to point out, as preface to understanding what that clause means, that the 1866 Civil Rights Act did not use the phrase "and subject to the jurisdiction thereof." What it said instead was, born here, excluding Indians not taxed. That language, excluding Indians not taxed, was also used in the Constitution in the 3/5 Compromise. So it is very clear that if the framers of the 14th Amendment were looking for exceptions, it was with respect to Native Americans.
And we know that because the meaning of the phrase "and subject to the jurisdiction thereof" was litigated in an 1898 case called U.S. v. Wong Kim Ark, which the facts there are almost identical to the executive order. Wong Kim Ark was born in San Francisco in 1873 to Chinese immigrant parents. And in 1889, when he was a teenager, his parents returned to China and took him with them. 6 years later, Wong tried to come back to the U.S., and he was denied reentry on the theory that he was not a U.S. citizen. And the government's argument was that Wong's parents were not subject to the jurisdiction of the United States because they were Chinese subjects. And the Supreme Court said that is not what subject to the jurisdiction means.
Yeah.
Instead, they said the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, including all children here born of resident aliens, with the exceptions or qualifications of children of foreign sovereigns or their ministers. So, you know, the ambassador's son doesn't get U.S. citizenship, or people born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. The amendment, in clear words and in manifest intent, includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States.
That is abundantly clear. But I have to read the next sentence, which is so clear that even Donald Trump's cronies couldn't have missed it. They say, every citizen or subject of another country, while domiciled here, is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. So there you have it. In 1898, the Supreme Court said that the 14th Amendment meant use solely, excluding a couple of teeny tiny edge cases, children of diplomats and hostile invading army, and that huge asterisk of Native Americans.
And then in 1924, Congress passed the Indian Citizenship, which said that all non-citizen Indians born within the territorial limits of the United States be and they are hereby declared to be citizens of the United States. So that crossed out the asterisk, and now we are left with the 14th Amendment, which means if you are born here, you are a citizen.
Yeah.
Although, counterpoint, birthright citizenship is not about rich people from China and the rest of the world who want their children and hundreds of thousands of more for pay to ridiculously become citizens of the United States of America. It is about the babies of slaves. We are the only country in the world that dignifies this subject with even discussion. Look at the dates of this long ago legislation. The exact end of the Civil War. The world is getting rich selling citizenship to our country, while at the same time laughing at how stupid our U.S. court system has become, parentheses, tariffs. Quote, dumb judges and justices will not a great country make. I do not know where this quote is. It is not sourced. I think it's maybe his feelings.
And look, we can laugh at you reading Donald Trump vomiting nonsense on Truth Social, but Solicitor General John Sauer made this argument in the administration's brief to the Supreme Court. There are multiple sections, multiple references to the non-existent industry of, quote, birth tourism. Mm-hmm. There's just naked appeals to, hey, you don't want these non-white people coming over here and becoming citizens. It is, I don't have a word for it.
All right. Well, we're going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you will go directly to us talking more about the birthright citizenship case.
And we're back. Okay, before the break, we established that Wong Kim Ark was a Supreme Court case that is directly on point and has been good law for 125 years. It definitively rules out the administration's argument. So what is the administration arguing? There is, Liz, one case that appears 16 times in the government's opening brief, far more than any other citation, shows up an additional 10 times in their reply, starting with the very first sentence. We're going to hear it a lot on Wednesday. That case is Elk versus Wilkins. The government says that this case imposes a long-term domicile requirement on citizenship. In other words, they say, because of the rule in Elk, it's not enough to be born here to qualify as subject to the jurisdiction of the United States. You must be, and as I flagged at the beginning of the segment, completely subject to that jurisdiction. And the way in which you demonstrate that you are completely subject to the jurisdiction is through, this is their words, generations of parental domicile.
So the government's argument here is that at least two broad classes of people are not completely subject to the jurisdiction of the United States. First, they have what they call temporary sojourners, by which they mean children of immigrants who are here on visas. And second are immigrants who are here outside of legal status. So the government argues that those people are not completely subject to the United States jurisdiction because they're also subject to the jurisdiction of their native countries, and they don't count.
I almost don't know where to begin, right? First, the temporary sojourners argument has an incredibly broad range, right? Like it is the same argument that John Eastman made when he said that Kamala Harris did not qualify as a U.S. citizen, even though she was born in Oakland, California, because if your parents were here on a temporary visa, at some point they were going to go back home, so therefore they didn't have proper allegiance to the United. I mean, it's incalculable how far this would sweep. Second, that's not what Elk v. Wilkins says, right? As you might garner from Elk was a member of an indigenous tribe. And what he did was renounce his tribal citizenship and then tried to claim American citizenship. And he said, look, I was born here in this country. I get citizenship under the 14th Amendment. And the Supreme Court said, no, you were born on tribal lands. And although those are, and I'll use the Supreme Court's language, in a geographical sense in the United States, you were legally born in a separate sovereign nation. And third, even if that were what Elk v. Wilkins said, even if it was about loyalty and not about tribal sovereignty, that would not possibly, couldn't possibly make any difference because Elk was decided in 1884, which predates Wong Kim Ark by 14 years. So even if the rule in Elk were different, the most we could say is that the rule was then superseded 14 years later in the Wong Kim Ark decision, right? And that would be a particularly persuasive argument in this particular case because both of those opinions, both Elk and Wong Kim Ark, were written by the same person, Supreme Court Justice Horace Gray.
Right, who was presumably not overruling himself.
Right.
So in
he
other
would have
words,
said that. He knew what he said.
right. Elk is consistent with Wong Kim Ark. There's no independent requirement of, quote, complete loyalty before you can be a citizen. It's just a language that the Supreme Court used in the late 19th century when it was struggling to articulate a reason to exclude Native Americans. And in fact, the authors of the seminal textbook on Indian law wrote an amicus brief to say exactly that. We can link to that brief in the show notes. But essentially, the scholars confirm that Elk was about the single uniquely American exception to birthright citizenship. It does not invite the government to question the loyalty of the parents of children who were born here, or indeed the children themselves.
Yeah. I really cannot overemphasize. So that's the legal framework, right? I can't tell you how bad the government's lawyering is here. I mean, it is full of things that are either rank incompetence or out and out lies, or possibly both. I do want to highlight two of them. I mean, there are many from which I could choose, but these are two of the most egregious. So first, one of the arguments that the government makes is that in the debate over whether to ratify the 14th Amendment, and again, I'm going to quote their language directly, lawmakers agreed that the citizenship clause of the 14th Amendment would not cover someone who is, quote, born here of parents from abroad temporarily in this country. Okay. So never mind that in the mandatory detention cases we were talking about, the government has argued in court that that legislative history doesn't count, that courts should only go by dictionary definitions. I mean, here they're trying to argue that the legislative history supports their argument, so they're happy to cite it. But I don't want to get bogged down in accusing them of flip-flopping, because I think legislative history does tell us what the drafters of the 14th Amendment meant by the words that they chose. So in one sense, I'm happy to see the government cite it. I'm less glad to see them lying about it. In their initial brief, the government cited the Congressional Globe. And that was the written record for the congressional debates during, as like 1830 to 1880, right? They cited the 39th Congress, first session, page 2769. That was for the is born here of parents from abroad, which they put into quotes. And just as a law geekery practitioners do, when a lawyer says that, what they're saying is that one of the drafters of the 14th Amendment said during debate that that's what the citizenship clause means. That's why you said it that way.
But that wasn't actually true. And in fact, the plaintiffs in this case noticed. They said the government quotes Senator Fessenden's words, quote, born here of parents from abroad temporarily in this country, as if they were a statement of such a rule. But Fessenden was asking a question whether the child of temporary visitors would be a citizen under existing law. In response, Senator Wade, a primary supporter of the clause, confirmed that such a child would be a citizen. Quote, the senator says a person may be born here and not a citizen. I know that is so in one instance in the case of the children of foreign ministers, but it could hardly be applicable to more than 2 or 3 or 4 persons.
Yes. To be clear, the government deliberately misquoted a question as if it were a statement of congressional intent, and then omitted the answer, which was no. And then after being called on that in the respondent's opposition brief, that citation, the reason that I specified, page 2769, shows up 0 times in the government's reply brief.
Well, what do you want
How
from them?
intriguing. Okay. Second example. One of the very many strong arguments against the government's misreading of the 14th Amendment is that every president, every Congress, every Supreme Court has consistently interpreted the 14th Amendment as guaranteeing birthright citizenship. So they're stuck in this position on a lot of things, right? How do you explain that everybody else in human history got it wrong, but only Donald J. Trump, legal genius, managed to discover the true interpretation in 2025? And their answer, I swear to you, I'm not making this up, is that it's all the fault of that dastardly, obscure president, Franklin D. Roosevelt, who, this is their words, that Roosevelt, quote, started misreading the citizenship clause starting in 1939. And then they say FDR's reading, quote, was not universally accepted among lawyers. And they have a citation to 2 commentators who apparently agreed with their theory.
I mean, not universally accepted by every single lawyer in the country. Come on, there's people out there who don't believe in gravity, right? You can find some idiot to believe any dumb shit you like, especially if there's money in it. Looking at you, John Yoo and John Eastman. Like, yes, the existence of people who believe the opposite doesn't mean there's really a debate,
Yeah.
right? The question isn't what a couple of randos thought. It's what Congress and the courts thought. And we know what they thought. They universally believe that the 14th Amendment protects birthright citizenship.
Agree 100%, but it's actually worse than that. Because I've buried a particularly valid point, because I've buried a particularly salient piece of information. And that is the first commentator that the government refers to as, quote, one writer said, a child born at Ellis Island to alien parents while awaiting admission to this country apparently will remain an alien. Which, okay, you might say that one dude thought a thing that the government also thinks. But that citation is to note the Nationality Act of 1940, 54 Harvard Law Review, page 860.
They're citing a law review? Like they're citing no. I mean, they're citing a second or third year law student to prove that this is a debated, hotly debated issue.
That is true. That is what note means, right? And I looked up a copy of this online. It's paywalled over at JSTOR, but if you're a student or an academic or you have a JSTOR account, I will link to it in the show notes. It is 10 pages long. It is an unsigned student piece. And look, I don't want to overly poo-poo the work of law students and young lawyers that I was once both of those, right? You can do good work. Mm-hmm. But typically when you do stuff that gets cited at that part, it has to be running to ground, right? Like I'll give you an example from early in my career. Like when I was a summer associate, we had a case that involved the George Washington Bridge. One end of that bridge is in New Jersey, one end is in New York. So in cases like that, you have to have an interstate compact, which is a thing that's authorized by Article 1, Section 10, Clause 3 of the Constitution. And my job as a summer associate was to pull and review every single interstate compact as of 1996, which I think I did good work. But that's exactly the kind of thing for which, you would put a student or a very young lawyer on. The idea that you would find a radical new take on American jurisprudence in the pages of a student note is preposterous. And as it turns out, not true. Because once again, the government quoted this anonymous student. Now, they're already scraping the bottom of the legal authority barrel, and they quoted it out of context. Because, as the title of the law review note might suggest, this was about legislation, the Nationality Act of 1940. So the students comment in the section on page 2 that they quote about being born while your parents are in the queue at Ellis Island was talking about the law, the Nationality Act of 1940. But part of the note that later talked about the 14th Amendment said that the citizenship clause of the 14th Amendment, quote, reaffirmed common law as the basis of American birthright citizenship with a citation to, drumroll please, Wong Kim Ark.
Okay, so to recap, the law is very, very clear that the 14th Amendment protects birthright citizenship. And we'll know if the justices on the Supreme Court take this framing at all seriously, probably within the first 5 minutes of this argument. And they should not. To be clear, they should not.
Yeah. And I should add, as we wrap this up, that there's no shortage of things to criticize in the government's argument here. Right? We already talked about how it invokes the specter of birth tourism. That's a racist phrase that John Sauer uses 9 times throughout the government's opening brief. Mm-hmm. They say, real quote, it degrades the meaning and value of American citizenship. They say that it risks America's national security. It provides a powerful incentive for illegal migration. This is a press release to the white supremacists who support this administration. It should not be taken seriously in court. None of that, even if every single one of those things were true, which, by the way, are not, that wouldn't tell us what the 14th Amendment meant. But I mean, that is where we are. And I sure hope that we are at least minimally served by the Supreme Court on Wednesday. We will be there to tell you about it.
Okay, that is going to do it for us today. Listen, we will not be here on Thursday with our written post or on Friday with the show because it is Passover. We will, however, be listening to the Supreme Court's oral arguments, and we'll be back to talk about them next Tuesday. If you are celebrating Passover, don't forget to drink lots of water and eat fruits. Eat your haroset. And if you are celebrating Easter, have a lovely, meaningful holiday. We will be back and talk to you soon.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.